the Child Care and Protection Act, Section 72, Jurisdiction of Children's Court. Subsection 1. Subject to the provisions of this section, no charge against a child and no application in relation to a child in need of care and protection shall be heard by any court of summary jurisdiction which is not a children's court. Subsection 2. Subject to subsection 3, a charge made jointly against a child and a person who has attained the age of 18 years shall not be heard by a children's court. Okay. So if an adult and a child are jointly charged, that case will not be heard in the children's court. Alright. Subsection 3. Where in the course of any proceedings before a children's court it appears that a person so jointly charged has attained the age of 18 years, A. Nothing in subsection 2 shall be construed as preventing the children's court, if it thinks fit, from proceeding with the hearing and determination of those proceedings, and B. Where it does so, it shall be deemed to have in relation to the person who has attained the age of 18 years all the powers of a court of summary jurisdiction. Where it does so, it shall be deemed to have in relation to the person who has attained the age of 18 years. Okay, so seems as if the case could still be heard in the children's court. It says nothing in subsection 2 shall be construed as preventing the children's court, if it thinks fit, from proceeding with the hearing. Okay, so if a child and somebody who already attained the age of 18 are jointly charged with an offense, that offense would normally go to another court instead of the children's court. But if the court thinks fit, then it will take on that case. If the children's court thinks fit, that case can be heard in the children's court. Okay. Subsection 4. Where a child is charged with an offense, the charge may be heard by a court of summary jurisdiction, which is not a children's court, if a person who has attained the age of 18 years is charged at the same time with aiding, abetting, causing, procuring, allowing, or permitting the offense. Subsection 5. Where in the course of any proceedings before any court of summary jurisdiction other than a children's court, it appears that a person to whom the proceedings relate is a child, nothing in this section shall be construed as preventing that court, if it thinks fit, from proceeding with the hearing and determination of those proceedings. So it seems as if another court, a court of summary jurisdiction, has somebody in front of the court and it seems as if that person is a child, the court is not forced to hand over the case to the children's court. It can still go ahead and try the case. Seems to be what that is saying. Subsection 6. Where a child, A, who has not attained the age of 14 years is charged with any offense, or B, who has attained the age of 14 years is charged with any offense other than an offense specified in the 4th schedule, the charge shall, subject to any right of appeal provided by this or any other enactment, finally be disposed of by a children's court, or if the charge is heard before a court of summary jurisdiction that is not a children's court, by that court of summary jurisdiction without prejudice, however, to the provisions of Section 75. Okay, so in that case, what it says, while being charged, the age of 14 is charged with an offense. So even though the person, the child, has not attained the age of 18, once they are 14 or above, then their case can be tried in a court other than the children's court. Subsection 7. Where a child who has attained the age of 14 years is charged with an offense specified in the 4th schedule, A. Proceedings for the child's committal for the child shall, subject to subsection 1, be heard in a children's court, and B. If on the termination of those proceedings the court is satisfied that the child should be committed for trial, the court shall so commit that the child so and shall bind such child and the witness by reconnaissance to appear at court to which such child is committed. Subsection 8. No direction, whether contained in this or any other enactment, that a charge shall be brought before a children's court shall be construed as restricting the power of any resident magistrate court or justice of the peace to entertain an application for bail or for remand and to hear such evidence as may be necessary in that purpose. Okay. Of Section 73, provisions as to powers of children's court. We'll look at that in our next video.